Brother here in the area of Argentum Exploration Limited and Republic of South Africa.
Yes, Mr. Hoffman.
One correction for the record, just in relation to our written case. We needn't turn it up. It's page 128, paragraph 96.1. The last line of the paragraph on that page, where the word unknown should be corrected to known.
Sorry, just give me that again.
Page 128, paragraph 96.1, last line. Commenced where the owner of the cargo, it should read, is known, not unknown.
Sorry, the reference again, please, Mr. Hoffman.
Page 128. Page 128.
Yes.
Paragraph 96.1, the base of the page.
Yes.
Last line. Commenced where the owner of the cargo is, it should read known. Apologies for that error. I begin this morning with the 4 items of context, and I go first to the Brussels Convention, page 1996 in the English. One purpose of the State Immunity Act was to give effect to the Brussels Convention, even though, as Lord Sumption stated in Benkarbush at paragraph 10, the Convention had been largely superseded by the adoption of the restrictive doctrine of state immunity at common law. Well, what is the function of the Brussels Convention? First, it's a tool for interpretation of the State Immunity Act. The English courts do not apply the Brussels Convention directly. Further, it is the interpretation given to the Brussels Convention by the drafters of the Act that is relevant, not what others might consider is the true meaning of the Brussels Convention. In summary, we submit that properly construed, the Brussels Convention supports Argentum's case, and it does not contemplate that the RSA would be immune from a claim of this kind. As I say, the Convention in the English begins at 1996. If we start at Article 1, we see the basic presumption of the Convention: seagoing ships owned or operated by states, cargoes owned by them, and the cargoes and passengers carried on state-owned ships, as well as the states which own or operate such ships and own such cargoes, shall be subject, as regards claims in respect of the operation of such ships or in respect of the carriage of such cargoes, to the same rules of liability and the same obligations as those applicable in the case of privately owned ships, cargoes, and equipment. So it applies directly to cargoes owned by states, amongst other things. As regards claims in respect of the carriage of such cargoes, they shall be subject to the same rules of liability and the same obligations as those applicable in the case of a privately owned cargoes and equipment. This includes the obligation for present purposes to pay salvage. Then Article 2 over the page, as regards such liabilities and obligations, the rules relating to the jurisdiction of courts, rights of action and procedures shall be the same as for private cargoes and their owners. So this provision effectively affirms that, as regards Article 1 liabilities and obligations, the domestic rules relating to the jurisdiction of the courts shall be the same as for private cargoes and their owners. Put another way, a state is not immune with respect to such claims. This, it might be added, is consistent with the restrictive immunity. The state is only immune with respect to sovereign acts, to which we come in the next article. It might also be added that Article 2 draws no distinction between in personam and in rem claims. Both are captured in the wording of the provision. the provision also affirms that the same domestic legal actions and the same domestic procedures apply in the case of a claim within the ambit of Article 1. And then, in Article 3, we see that immunity is introduced by reference to these sovereign acts, with the state claiming immunity bearing the burden of proof in a manner consistent with the restrictive immunity. Article 3 has 3 paragraphs, taking each in turn. The first paragraph introduces immunity for ships in use for governmental, non-commercial purposes, such as warships. And each of the various ships is identified, owned and operated by a state and employed exclusively at the time when the cause of action arises. The word exclusively is important, on governmental and non-commercial service, and such ships shall not be subject to seizure, arrest, or detention by any legal process, nor to any proceedings in rem. Pausing there, it's common ground that the vessel in this case doesn't fall into this category. It was not owned by the RSA. It was a privately owned trading ship. And then immediately below, we see certain exceptions to this immunity introduced, but only before the courts of the state that owns and operates the vessels. Nevertheless, toutefois, claimants shall have the right to proceed before the appropriate courts of the state which owns or operates the ship in the following cases, and they're set out, and the state shall not be entitled to rely upon any immunity as a defence. And the 3 classes of non-immune proceedings are identified, the second of which is claims in respect of salvage, or in the nature of salvage and in respect of general average. So the short point is, if you salve a warship, the state that owns the warship is immune from any claims of salvage, save before its own courts. It is a carve-out of the immunity introduced by Article 3.1, first paragraph. Article 3...
Mr. Hoffman, immunity doesn't apply before a state's-owned court.
Absolutely. No, there's no immunity in the state-owned court. That is correct. The nevertheless is providing, stating that, of course, before the state-owned court, you may take those proceedings. Yes. Article 3, paragraph 2, introduces an immunity in respect of cargoes carried on board the vessels mentioned in paragraph 1. The same rule shall apply to state-owned cargoes carried on board any of the above-mentioned ships. So, again, that's not the case that we're concerned with. Talawa was not such a vessel. Then Article 3.3 discusses the situation that is applicable here. State-owned cargoes carried on board merchant ships shall for government and non-commercial purposes, carried on board merchant ships for government and non-commercial purposes shall not be subject to seizure, arrest or detention by any legal process, nor to any proceedings in rem. Nevertheless, claims in respect of salvage, or in the nature of salvage and in respect of general average, may be brought before the court which has jurisdiction in virtue of Article 2. So what this provision does is introduce an immunity in the first paragraph, first subparagraph, This time it is for all claims for a seizure, arrest, or detention, enforcement jurisdiction, not this case, and in rem claims concerning state-owned cargoes carried for sovereign purposes on merchant vessels. So it is an exception to the rule set out in Article 2. The important part of this is to understand what the first subparagraph of Article 3.3 is intended to address. The concern of the parties to the Brussels Convention is plainly the idea that a sovereign cargo, that is, cargo carried on board a merchant ship for government and non-commercial purposes, could be diverted from its path. So seized or arrested or detained. And in this connection, the inclusion of in rem proceedings in this grouping makes sense, at least insofar as the enforcement aspect of in rem proceedings are concerned. It is difficult to understand an objection to the adjudicative aspects of an in rem claim in this context.
Can you separate out the adjudicative and enforcement aspects of an in rem claim?
Yes.
Because, as I understand it, if you issue an in rem claim form, you can immediately instruct the Admiralty Marshal to arrest the vessel.
You can, but
you don't need to do anything else.
You can do that if you wish to invoke the court's adjudicative jurisdiction only. You issue the claim form and you attach it to the mast of the vessel if it's a ship, or you attach it to the cargo.
Yes. No
arrest or detention or seizure is involved at all. It is merely a step taken to found jurisdiction. That is
you can immediately. You don't have to wait for any order or judgment or anything from the court before you actually arrest the cargo or vessel. Is that right?
If you choose to arrest the vessel, yes.
Yes.
But once you get into arresting the vessel, you're moving into the enforcement regime. But there is and this is a critical aspect, which in our submission, the Lord Justice Elizabeth Lang failed to apprehend. She failed to understand the true nature of in rem proceedings, that there is both an adjudicative element and an enforcement element.
Well, the fact that the wording refers to seizure, arrest or detention, that clearly has in mind arrest of the vessel or cargo.
Yes.
So the reference to proceedings in rem must be intended to add something.
You accept that it does cover proceedings in rem?
I accept that it does cover proceedings in rem.
So whether you think it ought to or not, the fact is they are being treated in the same way in the Brussels Convention.
Well, at this stage, before you come to the second subparagraph.
Yes, but I think it follows from what you've told us that to any proceedings in rem must be addressing the adjudicative function.
At this stage, yes.
At this stage?
Yes.
Right.
And we will never, in this case, we will never get to the enforcement stage.
No, but anyway, that's it, yes.
And what I was saying was that what the concern here was a sovereign cargo being diverted from its path, being held up, and this is confirmed by the authorities that the RSA has put in the bundle concerning the Brussels Convention, and so if one goes to the supplementary authorities...
I'm sorry, I'm still not with you quite, because if we're focusing on the first part of 3.3.
Correct.
And it, as it were, prohibits proceedings in rem.
It does.
So why do we need to be concerned about diverting vessels from their path or anything of that sort? Because that's what happens if you arrest the vessel or seize it.
It's just the proceeding about arresting vessels. It's talking about arresting cargo anyway.
Yes, it is proceedings in rem as cargo, as opposed to arresting the cargo.
Correct. But then one comes to and I'll go to the authority in a moment, the second paragraph of Article 3.3 contains an exception to the immunity imposed in the first subparagraph.
As I understand it, you're saying that within the paragraph starting nevertheless is the adjudicative part of an in rem proceeding.
Correct.
Whereas I think your opponent says it just applies to in personam claims.
Well, one looks in vain to find any reference to in personam claims is number one.
But one doesn't find any reference to adjudicative part of in rem proceedings either.
Well, except really in context, the context is in rem proceedings. There'd been no mention of in personam proceedings. And the second paragraph is a carve-out of the first paragraph.
So what do you say is carved out?
We say that what is carved out, relevant for present purposes, is claims in respect of salvage or in the nature of salvage, which may be brought before the court which has jurisdiction in virtue of Article 2.
Whether brought in personam or in rem proceedings.
Correct.
And what about contracts relating to such cargoes? You can't have an in rem proceeding there, can you?
No, but
that can't be a carve-out from the first part.
No, sorry, I was too hasty in my saying yes. You can have can have claims in respect of contracts relating to cargoes where there is a salvage contract which is entered into to salve the cargo.
Yes.
And that would.
What I'm saying is that such a claim is not a proceeding in rem.
Well, a claim under a contract for salvage services would be or could be a claim in rem.
Okay.
So the word nevertheless in our submission makes it clear that the scope of the second subparagraph must be read as a carve-out of the first subparagraph. And as the first subparagraph concerns immunity from enforcement and in rem claims, the exception in the second paragraph in respect of claims must also be read as a reference to in rem claims. This second subparagraph makes it clear that in rem salvage claims are permitted. No immunity of any kind is introduced in relation to in personam claims, and the immunity which is introduced in relation to in rem claims it then has a carve-out in the second paragraph. And this makes perfect sense in the light of two things. The first subparagraph of Article 3.3 is concerned with a state's property being diverted from its course. It's concerned with enforcement against the state property. It covers adjudicative jurisdiction in passing, but its real purpose is clear. And secondly, it makes perfect sense in the light of the dual aspect of a claim in rem, one aspect being adjudicative and the other concerned with enforcement. And to confirm that, we can turn up the Supplementary Authorities Bundle, page 130. One of the texts referred to by Mr. Wordsworth yesterday, 130, Professor Edel, and in the final paragraph, which was not read.
Sorry, you're going to have to bear with me for a moment.
I'm so sorry.
Yes, so can you give me the page again?
Page 130.
No. Sorry about this.
This is the
final paragraph.
This is the International Law of the Sea, Volume 2, Internal Waters. Yeah.
Final paragraph. Finally,
I'm sorry.
I'm so sorry.
Yes, it is the International Law of the Sea. It is that page. Right. Thank you.
So which bit do you want us to read?
The final paragraph. Finally, well, you had read to you the 4th and 5th paragraphs yesterday, where again the reference is made to did it not exempt such cargoes from seizure. That's what's being talked about. And in the final paragraph, that's made clear. Finally, let us mention that the immunity from seizure granted to cargoes belonging to a state and transported on board merchant vessels for governmental and non-commercial aim is never accompanied by a privilege so far as concerns jurisdiction with regard to actions directed against the ships of commerce which transport them, or brought under contracts relating to these cargoes. These actions are in no way reserved to jurisdictions of the state which owns the cargoes. The Convention specifies that notwithstanding the immunity from seizure granted to the cargo, they must be brought before the tribunal having jurisdiction under Article 2. And in the previous authority, if one turns to page 96, I'm so sorry, not 96, to it's the next one, to page 164.
Sorry, 164.
In the supplemental bundle.
Yeah. 164.
Yes.
The last page.
Yes. It's the English translation. And
Where is the original? Just so?
the original is at page 476 to 477. Or 76 to 477 in the original.
So 155.
Sorry, yes, 155 to 156. Yes, I'm so sorry.
Thank you.
And 2/3 of the way through the first paragraph, again, the paragraph read to you yesterday, one cannot conceive, in fact, as was very well noted by Mr. Rieper, how a state would accept one could seize a cargo which it intended for a governmental aim that was transported on a merchant ship. Such a situation is not purely hypothetical. The dangers it poses are not fanciful. Many states use their procedure for the transport of arms, supplies and munitions intended for the use of their armed forces in their colonies and overseas possessions. The conference ended up by adopting this point of view and coming in this way to the way of seeing of the colonizing countries. It removed a serious obstacle to the ratification by the convention by these states. So we see that what was in mind at the time was the concern in relation to seizure. As a consequence,
Mr. Hopper, is this a new point?
I think it is.
Is this a new point?
no, it's a point that we argued at both the first instance and in...
Okay, where is it in your case?
It's not dealt with in detail in the case. It's
Is it dealt with at all?
No, that's right. It's the argument to which Lord Justice Popperwell refers when he deals with the Brussels Convention and the case which we advanced.
So which paragraph is that?
In the judgment, that's yes. Paragraph, the learned judge considered the matter in Article 3.3 at 41 and Article 40. Page 163, paragraph 41. Paragraph 42, the judge reports there was a dispute as to the nature of the carve-out in Article 3.3 for the specified types of claims. Argentum argued that it was a complete withdrawal of immunity in respect of the claims of this kind.
Sorry, where are we?
The consequence of Article 3,
I'm just not sure.
subsection 3.
Are you continuing with your submissions now? Or
I
are you
am
referring to? I see.
Yes, sorry.
Well,
I mean, I'm sure this is 3.1.
yeah.
Is
It looks as if Lord Justice Popper is responding to a slightly simpler argument than the one you're now putting, which is that the carve-out was a complete carve-out of in rem claims, i.e. claims of this kind, rather than just the adjudicative part of them.
That is a possible reading of it. He was concerned, however, only with the court's adjudicative jurisdiction. That was the battleground. We were dealing, the case concerns the adjudicative jurisdiction of the court.
But I mean, can you just help me a little bit more with what you mean by the adjudicative part of an in rem claim? Can the adjudicative part simply lead to an order for payment of salvage, or does it lead to an order that the cargo be sold so that a specified amount by way of salvage can be raised and paid to the salvor?
Again, it helps to understand the background in this particular case. The silver, the cargo, is held to the order of the receiver of wreck. The receiver of wreck has an obligation to deliver the cargo to its owner upon payment of salvage. The court, we say, has adjudicative jurisdiction by reason of the claim form having been attached to the cargo. This court is concerned with the RSA is immune from the proceedings which have been commenced, the adjudicative proceedings. If the court concludes that they are not immune, as the courts below have concluded, then the way in which the matter will proceed is that a salvage amount will be determined and the receiver of wreck will pay the cargo, will deliver the cargo to the RSA, or indeed in this case to those who've purchased the cargo from the RSA Odyssey, to which reference is made in the judgment.
Well, that might be right in relation to wreck, but what in relation to the adjudicative part of an in rem claim against cargo generally? Because it may be that wreck is a rather small subset of the sort of adjudication we're talking about. And this is a single piece of statutory language which has to apply across the board.
If the cargo was simply passing through the ports of the United Kingdom and the claim form was attached to the cargo, the cargo could move on, could leave, could carry on its journey, because it was not attached, seized or detained. But the court in this country would have adjudicative jurisdiction in respect of that in rem claim and could continue to determine that claim in this country And when it came to enforcement, then different procedures might need to be adopted.
Mr. Hofmeier, if you're right in what you say about Article 3.3, it would appear that the draftsman or drafter of the State Immunity Act, Section 10.4, took a different view. Which is maybe why this particular argument does not really seem to have featured before.
On any view, the drafter of the State Immunity Act has taken a different view to the Brussels Convention.
To your reading of the Brussels Convention, because it clearly distinguishes between in rem and in personam actions and says that where the relevant conditions are satisfied, there is immunity as regards in rem proceedings. Or you can put it the other way around, no immunity. If they can, but 10.4 distinguishes clearly between actions in rem and actions in personam.
It does.
In a way that seems to me, at any rate, to be inconsistent with the submission you're making about the meaning of Article 3.3 of the Brussels Convention.
Well, on one view, the Brussels Convention, it could be said, is concerned with the use to which the state is going to put the cargo, its intended use.
At the moment, I'm on actions in rem and actions in personam. I mean, the rather simple view that I had adopted, perhaps over-influenced by the drafter of the State Immunity Act, was that the first part of 3 was talking about seizure and so on and proceedings in rem, and the nevertheless bit was making it clear there could still be actions in personam.
But it wouldn't need to do that.
Oh, right.
Actions in personam the first part doesn't cover actions in personam at all.
Yeah, but that's why it's nevertheless. It's
however.
But why does the drafter of Section 10.4 just make this distinction?
Well, again, we don't know precisely what was in mind of the drafter.
No, we don't know. What we do know is he intended to give effect to the Brussels Convention.
Amongst other things.
Well, is that right?
Yes. And I will take you to
common
authority.
Ground in the Court of Appeal.
Sorry?
It was common ground in the Court of Appeal that Section 10 was intended to give effect to the Brussels Convention.
Amongst other things.
That's not what Lord Justice Popplewell said.
Well, I'll
Paragraph
take you to
38 or wherever it is.
I'll come to that when I come to deal with the restrictive theory, but this court and the House of Lords has said...
I just feel that you're sort of slightly reinventing history here, because Lord Justice Popplewell says in paragraph 38 it was common ground between the parties that Section 10 was intended to give effect to the Brussels Convention and thereby enable the United Kingdom to ratify it. Full stop, effectively.
I mean, can the State Immunity Act be made consistent with this interpretation of the Brussels Convention that you're putting forward?
Yes, that's our submission.
Well, I'm not sure it is your submission. I understand your submission's about in use and so forth, but this is a submission about the scope of in rem proceedings, and which proceedings fall within the division that's been drawn sounds to be different. You say that there's a different distinction there too between the two limbs of Article 3 from the distinction drawn in Section 10 between the two limbs of Section 10.4.
Yes, it's difficult to see, and that is why the judge at first instance said he found it very difficult to interpret or understand Article 3.3, that faced with precisely these issues. And one has to bear in mind that by 1978, as the House of Lords said in Appellant, and as Lord Sumption said in Bencarbouche, the drafter, it has to be read against the background of the Convention, but also the restrictive theory, which had become part of the common law.
But
forgive me, Mr. Hoffman, can you just hit on this, please, before we go any further?
Certainly.
I just want to be sure I've got this correct. What I wrote down was your submission that the second sentence of Article 3.3 is an exception to the rule in the first sentence, and it carves out salvage in both its adjudicative and enforcement aspects. Is that right?
No, it carves out only its adjudicative aspect.
Right, thank you.
I'm so sorry if I
No,
said
no,
that.
it's my fault, and I'm glad to have been able to
It was
clarify.
my summary of what
Well, that's what
Lord Justice Popplewell described the submission as having been in the Court of Appeal, but it's not that submission here, is it?
No. But on any view, the State Immunity Act has taken a more restrictive view, hasn't it, than your interpretation of the Brussels Convention? Because it has put into 4A actions in rem and has not drawn the same distinction and actions as you have between the adjudicative and the enforcement aspects.
Well, it has.
Or perhaps, I suppose, the enforcement is dealt with in a different section. Is that the point? In section 13? Yeah.
Has
but then-
drawn that distinction.
Well, that
then-
makes it worse for you.
Yes.
Yeah.
Because B would have to say an action in payment and an action in rem brackets apart from enforcement. You would be relying on 10.4b, not 10.4a. And you would have to read those words into 10.4b, wouldn't you, to make them work in accordance with Article 3.3 of the Brussels Convention?
The justification for 10.4b on the basis of the Brussels Convention is itself problematic.
But the short point is that 4A, on your interpretation of the Brussels Convention, has no counterpart in the Brussels Convention. 4A, does it?
In our submission, it is part of 4A can be derived from the Brussels Convention.
Because it's not limited to carried on board merchant ships, 4A. So insofar as it's carried on board state-owned ships, there's an overlap. But in relation to merchant ships, the two don't relate to each other.
I'm just working through the combinations of limitations. If the merchant ship is intended for use for sovereign purposes at the end of the voyage, then that would also be.
We're talking about cargoes here, though, aren't we?
Yes, but for the purposes of the jurisdiction in respect of cargoes, both the cargo and the ship have to be looked at.
I mean, I'm sorry, but I think it's impossible, isn't it, to read Section 10.4a, Section 10.4, as permitting an action in rem which doesn't satisfy 4a.
I'm so sorry.
It's permitting actions in rem,
Yes.
provided that all that is in 4a is satisfied.
4A of the State Immunity Act.
Yes.
Yes.
Yes. And otherwise not permitting actions in rem.
Correct.
But that's contrary to your submission, as I understand it, in relation to Article 3.3
Yeah.
Brussels Convention.
Correct.
Oh, I see. So, I mean, so the submission is that the Section 10.4 does not give effect to the Brussels Convention on its proper construction.
It doesn't do so perfectly. It does so.
Well, if it doesn't, it doesn't.
No, but
It's
that
more
is
restrictive on your.
More restrictive.
That is precise. It is more restrictive.
This is a new submission.
Yes.
Well, I'm sorry. It's my fault entirely that it comes to you as a new submission, and that
But
is
where is it dealt with below? Apart from the paragraph in Lord Justice, I mean, this would be centre stage, wouldn't it, as a submission?
The only argument that we had to address below was the argument as to whether 3.3 second paragraph related to in personam claims only. That was the.
And you say it doesn't.
And we said, it was said by my learned friend, yes, it was common ground. It's never been common ground that it's restricted to in persona.
Well, in that case, I would have expected this submission to have been dealt with very clearly by the Court of Appeal.
The Court of Appeal didn't consider it necessary to resolve the question.
Where do they say that?
42.
42.
Claims of this.
I see. Then he goes on to say in 43, the structure of 10.4 indicates the latter is how the drafter interpreted the convention.
Yeah.
Yeah. So your argument, which is recorded in 42, is complete withdrawal of immunity in relation to claims of this kind.
Can I just come back to your present submission, which is it somehow leaves the adjudicative part intact and able to be litigated. But what the court is adjudicating on an in rem claim against cargo, isn't it, is the existence of a maritime lien over the cargo and the amount which has to be paid for the release of that lien. Isn't that what it's doing?
No, a maritime lien is not a lien in the sense that it's used in the context of in other contexts. It is the language is perhaps inapt, and many of the textbooks deal with that. But it is the right arises as a consequence of the acts performed. And therefore, in this case, the salvage, as a matter of English law, gave rights, a maritime lien, from the moment that the salvage services were completed. That gives rise to certain rights. Those rights can be adjudicated upon without enforcement jurisdiction being utilised at all.
But they're rights in the nature of a right over the property, the cargo. That's why it's an in rem claim, isn't it?
Correct, but they're rights which are afforded by law, and they have nothing to do with jurisdiction. They exist as a matter of law.
As a matter of English maritime law.
Correct.
Yes.
And they give security. I mean, as you say, from the moment the salvage is done, the salvor has security over the vessel or the cargo, which I think ranks ahead of mortgages, for example.
Correct. Well, it has security, but it also has a claim for remuneration. Well, it need not exercise that security.
Yeah, that's an in personam claim, isn't it?
No, it's an in rem claim.
But how do you then enforce your in personam claim? You have to get a judgment, presumably, against the owner. And that, of course, needn't be the owner at the time. I mean, that could be a subsequent owner, couldn't it? Because the lien attaches to the property, whoever purchases it. Who would you actually have your personal claim against? Supposing the vessel or cargo is raised, but then sold. You have the lien attaches to the property, whoever owns it. But who do you have a personal claim against?
Whoever owns the property.
But not against the owner at the time of salvage?
Well, if there has been a transfer of ownership, correct.
Then no, okay.
That is the position, the common position in rem proceedings.
Wouldn't you need to get a judgment against that owner, which you could then enforce, presumably in conventional ways, without seeking to enforce the maritime lien?
You would get, without acknowledging service, you would get a judgment against the cargo,
Right.
which you could therefore only enforce at that stage against the cargo,
Yes.
wherever the cargo might be found
Yes.
in the world.
Yeah.
Well, assuming the jurisdiction where it's found will recognise the lien and the judgment.
Yes, of course, that's always the case.
But could you also get an in personam judgment against the owner for payment of the salvage?
Not unless the owner acknowledges service and
Who had an order for service out, let's say, came within a relevant gateway.
you can't get an order for service out of an in rem claim. You can only get
But what about an in personam claim?
an in personam claim. You can get, has happened in this case, permission to.
Yes, you've got two writs, or two claim forms here, haven't you?
I'm struggling to understand how an in personam claim can lie against anybody other than the owner of the cargo at the time of the salvage. I mean, the claim is that he incurred to you a personal obligation to compensate you for your salvage work. That's quite different from a subsequent owner who can only get the cargo by satisfying your lien. I mean, I may be wrong about that, but it's how it currently strikes me.
The lien is like a limpet attaching to the
Yes,
or limpet attaching, and therefore the new owner has acquired the raise with the lien attached to it, but it's not a lien in the sense of it's not restricted to a lien for security purposes. It is a maritime lien gives rise independently to a liability. That's the nature of a maritime lien in English maritime law.
So let's suppose that the cargo for some reason had become valueless at the time the in rem claims succeeded. One would think then that the subsequent owner of the cargo would just say, well, fine, I'm not paying you. You can have the cargo.
Correct.
I think you're saying, no, he'd be under a personal even though the cargo had become valueless.
Not unless he had acknowledged service and become personally a party to the proceedings. If he hadn't done that, then the relief would only be as against the cargo.
Can you give me an example of proceedings in rem that would not be carved out on your interpretation of the second paragraph of
Yes, if one goes to the statute, page 1689.
Is this the Senior Courts Act?
Correct.
Yeah.
Jurisdiction under 1A, any of the claims and questions mentioned in subsection 2, and
First ones are all about the ship.
sorry,
The first ones are all about the ship.
they are.
Then there are others.
There are others. S is immediately springs to mind on page 1690, claim for forfeiture or condemnation of the ship of all goods which are being or have been carried or have been attempted to be carried in a ship, or for the restoration of the ship or such procedure, or for draft of admiralty.
Those are maritime lien claims, are they?
those are claims in respect of which the
Or perhaps the simplest is a claim for loss or damage to goods carried in a ship.
yes.
That could be an in rem claim, and it's not within the second paragraph.
Well, it would be damage, shipping dangerous cargo, or cargo which has caused damage to the ship. But yes, it's a short answer to.
But there's no maritime lien in relation to that type of claim.
There's no maritime lien in relation to those in category S. No.
But then there's no apparent reason for wanting to make those.
Well, can I come to that? I'll address that in a moment.
Yes.
If I can just get through, because Article 5 comes into play as well.
Right.
But the consequence is that if a court under Article 2, say the Admiralty Court in London, has jurisdiction over an in rem salvage claim in respect of a private cargo under its own rules, Article 3.3 confirms that the state is not immune from a corresponding claim, even if the cargo is carried for government and non-commercial purposes. And that's exactly what's happening here. Although we have a further string to our bow, we deny that the silver was being carried for government and non-commercial purposes. Seen in this light, there is a careful balancing act being done between the first and second paragraphs of Article 3.3. The first paragraph removes the right to bring in rem claims in respect of relevant cargoes, both in its adjudicative and enforcement aspect, but the second paragraph reintroduces the right to bring an in rem claim without any concepts of seizure and arrest from which the subparagraph recoiled. Put another way, the state gets its cargo, but the salvor gets jurisdiction in respect of its claim. In this way, the interests of justice are served. And this is confirmed, moreover, we say, by the terms of Article 5, page 1998, if in any proceedings to which Article 3 applies, there is, in the opinion of the court, a doubt on the question of the government and non-commercial character of a ship or the cargo, a certificate signed by the diplomatic representative of the contracting state to which the ship or cargo belongs, communicated to the court through the government of the state before whose courts the tribunals the case is pending, shall be conclusive evidence that the ship or cargo falls within the terms of Article 3, but only for the purposes of obtaining the discharge of any seizure or arrest or detention affected by judicial process. So, if necessary, the state can get its cargo released through the use of a certificate, but the salvor will have jurisdiction for its claim, which will continue regardless. Thus, even if the Republic is correct in asserting that the silver was being carried for government and non-commercial purposes whilst on board Talawa, within the Brussels Convention regime, the Republic would not be immune in the Admiralty Court with respect to an in rem claim concerning the silver. And given that the silver is in storage within the jurisdiction, Article 2 would be complied with, because the Admiralty Court would have jurisdiction over such a claim if the silver were owned by a private person. Reading Articles 1, 2 and 3 together, if a state puts any cargo on a merchant ship, the Brussels Convention says that there is no immunity from the adjudicative aspect of an in rem or in personam claim. Obviously, this must be taken into account when dealing with the concept of use in Section 10.4a. A broad interpretation should be given to that word in consequence of the scheme of the Brussels Convention. Even if the Republic is correct in asserting, sorry, I've dealt with that. If contrary to this interpretation, the second subparagraph of Article 3.3 is concerned only with in personam claims, the key question becomes whether the cargo was being carried for government and non-commercial purposes. We say the words mean use or intended use. But even if we're wrong, this is how the provision has been interpreted by the drafter of the State Immunity Act. The Republic claims that the Article 3.3 can only refer to use to which the cargo is put at its destination, that is, when it is no longer cargo, but that cannot be correct. The provision uses the word carried in its present tense to direct the interpreter to the act of carriage itself at a point in time at which the subject of the claim is still cargo and not thereafter. And as Lord Justice Popplewell explained at paragraph 99 of his judgment, page 177, the words for governmental and non-government and commercial purposes do not mandate an inquiry only as to the intended use rather than use. To ask whether a cargo is being carried on a ship for commercial purposes is an inquiry as to why it is there. But to ask why is it being carried does not distinguish between its use and intended use. The question may admit of two answers, one being how it came to be there, and the other being what was intended to be done with it thereafter. The former is the relevant question because the context is salvage and what makes the property cargo. This is
I didn't understand that last point, sorry. Why you say the former is the correct?
That's what the judge. I was quoting from the judge.
Oh, you're just repeating what Popplewell said.
Correct.
Right. Okay.
Yes.
But you endorse.
The same point still applies when you come to justify. If you do.
Yes, we do, and I will. We say this is consistent with the ordinary meaning of the word purposes, plural, in Article 3.3, by which its drafters indicated that they considered both the present and the intended use of the cargo to be relevant. The cargo would be immune from a claim in rem only if both the possible uses were government and non-commercial in character. Certainly this is how the drafter of Section 10.4a understood Article 3.3, as they introduced the disjunctive or and reversed the focus of the provision so it became in use or intended for use for commercial purposes. If one of the possible uses of the cargo, actual or intended, was commercial within the meaning of the State Immunity Act, then the cargo would not be immune. Now, against this, the Republic relied on those passages from Van Slooten and Gidel as indicating what the drafters of the Convention had in mind was that solely the purpose of the cargo at its destination. The question then arises as to the relevance of that material. It appears to be hearsay evidence of what occurred at the Brussels conference. It doesn't reflect an official interpretation by the states parties to the Convention or their subsequent practice. It is therefore of no relevance at all to the interpretive calculus required by the primary rule of interpretation in the Vienna Convention, Article 31, which itself reflects customary international law. It can only be relevant as a supplementary means of interpretation under Article 32 of the Vienna Convention, and only weak supplementary means at that. It is not as though this is the actual travail préparatoire.
Do they exist? I mean, was there a record of the conference?
Not so far as I'm aware.
Presumably the parties have searched for this and found nothing.
So in the light of that, our submissions on the position taken there are as follows. First, that a clear and correct interpretation provided of Article 3.3 by the Vienna Convention as described. There is therefore no need to resort to supplementary material. academic interest only. Secondly, even if they were of more than academic interest, the drafter of the State Immunity Act, as I have described, interpreted the provision in a different way. And given that we're applying the State Immunity Act and not the Brussels Convention directly, it is their interpretation that is more important. Thirdly, even if this material were still to be considered relevant, it supports the other branch of our case, which is that Article 3.3, by its first paragraph, concerned with seizure or arrest of sovereign cargo, and by its second paragraph confirms that it is no difficulty with a claim in rem for salvage against such cargo, provided the cargo is not seized or arrested. Put another way, they cut both ways, and the Republic must take the rough with the smooth. For these reasons, application of Article 3.3 of the Brussels Convention to the present case leads to the conclusion that the Republic is not immune to Argentum's claim in rem with respect to silver. The reasoning is straightforward. Per Article 2, the default position is that the silver is not immune. At the same time, the vessel's status as a merchant ship and the silver's status as state-owned cargo mean that the RSA may, in principle, take advantage of Article 3.3 with respect to Argentum's claim. There is no immunity, full stop. But even if the second subparagraph is concerned with in personam claims, to establish the silver's immunity from the claim under Article 3.3, the Republic must prove that it was being carried for government and non-commercial purposes. Silver was placed on the vessel and became a cargo at the Republic's behest, pursuant to commercial contract of sale, contract of carriage, bill of lading. The silver's purpose on the vessel to fulfill those commercial relationships was therefore commercial in character, and the silver itself was a tradable commodity inextricably linked from the bill of lading, and it follows that the Republic may not avail themselves of Article 3.3. Put simply and consistent, we say, with the position at common law, had the Republic been an ordinary trader shipping the silver from Bombay to Durban, it would have behaved no differently than it did in 1942. Its claim to immunity under 3.3 of the Brussels Convention is therefore misconceived. But even if the silver was being carried for government and non-commercial purposes, the Republic is still not immune from the claim in rem for the reasons that I have provided.
What is within 3 on your interpretation?
Sorry, what is within 3?
3, yeah, Article 3.
Article 3.3.
Yeah, Article 3.3, yes.
What
would be an example
of what is called any arrest or detention in rem proceedings.
I know, but what sort of cargo? Sorry, I'm looking at the first part. What's an example of a state-owned cargo on a merchant ship that you say would not be for commercial purposes, for government purposes?
Rubber boots of the kind dealt with in Trentex being bought by the government for use in the army.
Why isn't that a commercial purpose on your interpretation?
Sorry, on my interpretation, sorry, that's correct. That is my interpretation.
Yes, I'm asking you to give an instance of when of what Article 3.3 could apply to if your interpretation is correct. It seems to be.
It could apply
to be futile.
No, it could apply to requisition a merchant ship given a requisition order to carry a state cargo.
So it would still be a merchant ship then, would it?
It would be a state-owned cargo carried on board a merchant ship, a ship that would be carrying other different cargo on a commercial basis, but where there was a requisition order by the state to carry particular cargo of armaments or whatever for the state's purposes.
Is that a requisition of the cargo or the ship?
That would be a requisition
of the ship, you're saying?
If it's a requisition of the ship,
I think you're saying of the cargo, because obviously if the ship is requisition, then presumably it sort of comes within Article 3.1,
yeah.
isn't it? Wouldn't it then be operated by the state?
Yes.
So you're talking about, so you've got a merchant ship, still acting as a merchant ship, but the government says you must carry these arms for us. But surely the government would still have to pay for the carriage of those goods, wouldn't they?
No, not in wartime. They might be able to, if it's a United Kingdom merchant ship, the government could give a requisition order at what would be referred to as effectively a slot use of the vessel for the purposes of carriage of a ship that was going to Brazil during the Falklands War and was asked to carry armaments to Brazil, where they'd be picked up by warships.
But it seems pretty pointless to carve out that category, because you'd surely be just as much concerned about your government property being taken to the war whether you've adopted that course or whether you're paying for it, paying the carriage. There's no relevant differences there in the state's interest in the cargo.
There's no relevant difference in the state's interest in the cargo, no. It's the means by which it's getting it to its destination.
Well, I can't see it as a rational interpretation of Article 3.3, drawing that distinction.
There it is. We say that it is possible to give example of a state-owned cargo being carried on board a merchant ship for government non-commercial purposes.
Well, not one that makes any sense of the provision, though.
In our submission, it does, if that ship met with a casualty and needed salvage services or towage services, or let's say salvage services, and as a consequence of that, the ship and cargo were saved, the salvor would have a claim against the cargo, despite the fact that it was being carried from A to B without there being a paid-for contract of carriage in place.
Yeah, but the whole interest of the state is in getting its cargo to the destination for the vital war use or whatever sovereign use it wants to make of it. It doesn't care about whether the ship is being, whether they're paying for the merchant ship or whether they're just ordering them to do it. That surely doesn't affect the underlying concern of this provision, which is protecting the cargo from seizure.
Correct. The underlying concern is to protect the cargo from seizure.
Yes, and that you're concerned about because of what you need the cargo for, not with whether you've chosen to carry it by paying the operator or by ordering them to carry it.
That is because you want to get the cargo to its destination, yes. But it's in circumstances where you're using the high seas to get the cargo to its destination, and where you, by doing so, you place yourself at risk of maritime circumstances giving rise to claims against your cargo.
But the instance you've given, my lord, is I would venture to suggest, a pretty unusual one.
Yes.
It seems remarkable that Article 3.3 is inserted in order to deal with this very unlikely or pretty unlikely event when it's commonplace for state-owned cargoes, which are going to be used for sovereign purposes, to be carried on merchant ships.
Yes, perhaps we suggest that government and non-commercial purposes is picked up in the State Immunity Act by use or intended use, and therefore it covers both of those.
Yeah.
Well, except that you basically exclude the relevance of intended use because you say it's always been used for commercial purposes just by virtue of the fact it's under a contract of carriage.
Yeah.
But not if it's not under a contract of carriage. If it's carried...
But then we get to the same anomalous distinction.
Yes. I'll only be repeating myself. We say, as the commentators make clear, 3.3 was there to avoid seizure, arrest or detainment, and for that reason however, in the second paragraph was reintroduced so that the claims could be pursued so long as the courts under Article 2 had jurisdiction. May I move on to second context? I see that I'm fast running out of time and I'm going to need to move as quickly as I can, and I do apologise. Salvage, the second item of context is salvage. Can I invite my lords to go to page 770 to the decision of the Court of Appeal in Falk and Scottish Imperial Insurance Company. And to the words of Lord Justice Bowen on page 770, middle of the page, the general principle is, beyond all question, that work and labour done or money expended by one man to preserve the benefit of the property of another do not, according to English law, create any lien upon the property saved or benefited, nor even if standing alone create any obligation to repay the expenditure. Liabilities are not to be forced upon people behind their backs any more than you can confer a benefit upon a man against his will. There is an exception to this proposition in the maritime law. I mention it because the word salvage has been used and there's a mention of the use of that word. With regard to salvage, general average and contribution, the maritime law differs from the common law. That has been so from the time of the Roman law downwards. The maritime law, for the purposes of public policy and for the advantage of trade, imposes in these cases a liability on the thing saved, a liability which is a special consequence arising out of the character of mercantile enterprises, the nature of sea perils, and the fact that the thing saved was saved under great stress and exceptional circumstances. No similar doctrine applies to things lost upon land, nor anything except ships or goods in peril at the sea. The salvor's remuneration is earned for services rendered. I finished the quotation. Salvor's remuneration is earned for services rendered, and the owner of the property sold is liable to the salvor for the amount payable in respect of the salvage. In the leading text, Kennedy and Rowe's Law of Salvage, I needn't take you to it, the relevant pages in the supplemental bundle at paragraph 101, but it identifies the circumstances, the ingredients of salvage, and one of those, well, the five are maritime circumstances.
What's the page reference?
I'm so sorry.
Did you say 101?
That was paragraph.
Paragraph 101.
Oh.
It's supplemental bundle
96, my lord.
96, yeah. Thank you.
Supplementary.
In the middle of the paragraph, the law of salvage applies where 1, in maritime circumstances, 2, there is a recognised subject of salvage, 3, which has come into a position of danger necessitating a salvage service to preserve it from a loss or damage, and 4, a person falling within the classification of salvors, traditionally called a volunteer, 5, is successful or meritoriously contributes to success in preserving the subject matter from danger. So those are the 4 ingredients. And the maritime circumstances, the maritime adventure, is an essential element of the entitlement to salvage. To claim salvage, the salvor has to plead and prove a maritime adventure, such that the maritime adventure forms part of the cause of action, and this is true of all the other ancient and rare theoretical causes of action, to which I'll come.
Does that mean anything more than it's on board a ship?
That it's cargo being carried on board a ship, yes.
And it doesn't matter whether it's pursuant to a contract or a requisition or gratuitous. So it just means cargo. I mean, it means cargo on board a ship. I mean, maritime adventure suggests some other overarching project. I think maritime circumstances is a bit more modest, but all it means is it's on a ship.
Yes, it's on a ship being carried from A to B.
Yeah.
Are you leading into a new topic now about causes of action, or is we still on the or what you were? I'm just seeing what this is to do with.
It's got to do with, by way of context, what salvage, the ingredients of salvage are.
I know, but where's that taking us?
It's taking us to. It's taking us to a point where, for the purposes of making the claim in salvage, one needs to point to the fact that what is being sold was cargo carried on board a vessel.
Right, but we all know that it was in this case. So, sorry, perhaps best let you develop the argument, but I've no idea what the relevance of this point is to the issues in the case. It's common ground that there was a cargo on a vessel which sank to the bottom of the sea and was sold.
Yes. I should have gone, perhaps it was my mistake in hurrying. I was intending to go to the restrictive theory before I came to salvage, because the principle of restrictive immunity is relevant to the area of salvage, and perhaps the best thing is for me to go back to the course that I ought to have adopted and move straight to the restrictive theory first, if I may, and then come back to salvage.
Would it assist, Mr. Hoffmer, if we took a short break now and then...
Thank you so much.
You can take up your submissions at that point when we return. Thank you very much. We'll just take 5 minutes. Mr. Hoffman.
The next item in context I will address is the restrictive theory of adjudicative immunity in customary international law. Why is it relevant? Please turn to page 596. 596. Lord Diplock giving the leading speech in Alcon and the Republic of Colombia, a speech with which the other four law lords agreed, he identifies at E the question which the court is concerned with. The question of law is whether the English High Court has jurisdiction in garnishee proceedings to order the attachment of the whole or part of the balance standing to the credit of a foreign state in such an account, and then begins to answer the question in G. The answer to this question depends upon the true construction of subsections 2b and 4 of section 13 of the State Immunity Act 1978. The Act, as its short title indicates, deals primarily with relations between sovereign states, though its provisions are capable of extension by order in council in relations between the United Kingdom and the constituent territories of federal states. Accordingly, its provisions fall to be construed against the background of those principles of public international law as generally recognised by the family of nations. The principle of international law that is most relevant to the subject matter of the Act is the distinction that has come to be drawn between claims arising out of those activities which a state undertakes iure imperii in the exercise of sovereign authority, and those arising out of activities which it undertakes iure gestiones, transactions of the kind which might appropriately be undertaken by private individuals instead of sovereign states. And one sees that the language he uses there is language which can be found tracked in section 3.3c in relation to other transactions and activities. So that's the reason why it's relevant. And if we then turn forward to page 625, the speech of the judgment of Lord Sumption in Bencarbush, and in particular to paragraph 10 on page 625, at F to G, he says one purpose of the State Immunity Act was to give effect to the Brussels and Basel Conventions and thereby enable the United Kingdom to ratify them. It did this in both cases in 1979, but by this time the conventions had been largely superseded by the adoption of the restrictive doctrine of state immunity at common law. The Act therefore dealt more broadly with state immunity by providing in Section 1 for a state to be immune from the jurisdiction of the courts of the United Kingdom, except as provided in the following parts of Part 1. The exceptions relate to a broad range of acts conceived to be of a private law character, including widely defined categories of commercial transactions and commercial activities, as well as contracts of employment and enforcement against state-owned property used or intended for use for commercial purposes. And then he quotes from the speech of Lord Diplock in Alcom. Thus, when construing the State Immunity Act, one must do so against the background of the principles of customary international law, including in particular the dichotomy between sovereign acts on the one hand and all other acts on the other hand. The court is familiar with the reception of the restrictive theory in this country, and in countries such as Australia, this country, United States, a foreign state is not immune in disputes concerning commercial transactions or commercial activity performed by the state. In England, it happened in this way. The courts came to appreciate that customary international law required that only restrictive immunity be granted to foreign states, and on that basis they identified the parameters of the doctrine and incorporated into the common law, running ahead of Parliament. At the outset, it's important to point out that the authorities to which I will refer concern immunity from the adjudicative jurisdiction of the courts, the dynamic as it pertains to enforcement jurisdiction, that is, that the immunity that state-owned property enjoys from arrest or seizure is different. In Benkarbouche, Lord Sumption sets out the distinction between the two immunities at paragraph 8. And he traces the history in relation to that at paragraph 8, which is page 624 over to page 625. Before 1978, state immunity was governed in the United Kingdom by the common law. Properly speaking, it comprised two immunities whose boundaries were not necessarily the same: an immunity from the adjudicative jurisdiction of the courts of the forum, and a distinct immunity from process against its property in the forum state, that is, immunity from enforcement. And then he summarises the development of the common law, refers over the page 625 to the position that common law had changed as a result of the decision in the Philippine Admiral and the Court of Appeal in Trentex. And he states, these decisions mark the adoption by the common law of the restrictive doctrine of sovereign immunity already accepted by the United States and much of Europe. The restrictive doctrine recognised state immunity only in respect of acts done by a state in the exercise of sovereign authority, iure imperii, as opposed to acts of private law nature, iure gestiones. Moreover, and importantly, the classification of the relevant act was taken to depend on its juridical character and not the state's purpose in doing it, save in cases where the purpose threw light on its juridical character. I won't have time to go to Trentex, so let me go straight to Premio Congreso del Partido, which is page 1209. This remains the leading authority on the scope of the restrictive theory in customary international law, as produced by the courts of this country. The facts, as you heard, are complicated, involving Cuba's conduct with respect to true trading vessels, the Playa Larga and the Marble Islands. But the short point is that Cuba, by its actions with respect to the Playa Larga in particular, had caused a contract for the delivery of a cargo of sugar to be breached by a state-owned trading company, Mambisa, for foreign policy reasons. It did not approve of the removal of the Allende government in Chile. Premio Congreso is the case in which Lord Wilberforce gave the definitive statement about the scope and principles of restrictive immunity at common law. And we can start at page 1255. Sorry, that's a bad reference. 1225, I do apologise, 1225, where Lord Wilberforce sets out the law, beginning at the top of the page. An interesting starting point is on the relevance of statutes to the contents of customary international law, which he sets out at D to E. And then over the page, page 1226, D to G, we see criticism of the distinction between in rem and in personam claims drawn by the Privy Council in the Philippine Admiral.
So where is that, please?
1226, D to G.
Thank you.
Sitting in this House, I would unhesitatingly affirm, as part of English law, the advance made by the Philippine Admiral, with the reservation that the decision was perhaps unnecessarily restrictive in apparently confirming the departure made to actions in rem. In truth, an action in rem as regards a ship, if it proceeds beyond the initial stages, is itself, in addition, an action in personam. And he refers the owner of the ship in the Christina, the description in rem denoting the procedural advantages available as regards service, arrest and enforcement, it should be borne in mind that no distinction between actions in rem and actions in personam is generally recognised elsewhere, so that it would in any event be desirable to liberate English law from an anomaly if that existed. In fact, there is no anomaly and no distinction. The effect of the Philippine Admirable, if accepted, as I would accept it, is that as regards state-owned trading vessels, actions, whether commenced in rem or not, are to be decided according to the restrictive theory. On the following page, 1227, beginning at C, it is necessary to start from first principle. The basis upon which one state is considered to be immune from the territorial jurisdiction of the courts of another state is that of parem parem, which effectively means that the sovereign government acts of one state are not matters upon which the courts of other states will adjudicate. The relevant exception or limitation, which has been grafted upon the principle of immunity of states under the so-called restrictive theory, arises from the willingness of states to enter into commercial or other private law transactions with individuals. It appears to have two main foundations. A, it is necessary in the interests of justice to individuals having such transactions with states to allow them to bring such transactions before the courts. B, to require a state to answer a claim based upon such transactions does not involve a challenge to or inquiry into any act of sovereignty or governmental act of that state. It is, in accepted phrases, neither a threat to the dignity of that state nor an interference with its sovereign functions. And then immediately below, we see the test for the dividing line at common law between the two categories of acts. When therefore a claim is brought against a state, skipping to the end of and the state immunity is claimed, it is necessary to consider what is the relevant act which forms the basis of the claim. Is this, under the old terminology, an act iure gestionis, or is it an act iure imperii? It is a private act, or is it a sovereign public act? A private act meaning in this context an act of a private law character, such as a private citizen might have entered into. Running ahead of myself for a moment, so when a state behaves in a way that one might expect a private person to, say by putting cargo purchased commercially on board a commercial trading vessel pursuant to a commercial contract of carriage, and then having the benefit of salvage, they should not expect to have the benefit of state immunity, which by its nature attaches only to sovereign acts.
That assumes that the claim arises out of an activity of the state.
Correct, and that's why I was going to come back to the cause of action on salvage to show what the activity is on the part of the state.
Thank you.
And this is significant, Lord Wilberforce turns to the phrase coined by Lord Denning in the Court of Appeal, once a trader, always a trader, and sets out a vital qualification at page 1228 C to D. Picking up in the second paragraph, last two sentences, an assertion, once a trader, always a trader, but this may be an oversimplification. If a trader is always a trader, a state remains a state and is capable at any time of acts of sovereignty. The question arises, therefore, what is the position where the act upon which the claim is founded is quite outside the commercial or private law activity in which the state is engaged and has the character of an act done iure imperii? The restrictive theory does not and could not deny capability of a state to resort to sovereign or governmental action. It merely asserts that acts done within the trading or commercial activity are not immune. The inquiry still has to be made whether they were within or outside activity. And then we see a comment on commercial obligations in the context of shipping law and international sale of goods, D to G. In many cases, the process of deciding upon the character of the relevant act presents no difficulty. In the Philippine Admiral, once it was accepted that the contract for goods, the obligation to repay disbursements, and the charter party were of a trading or commercial character, and the breach of these obligations was clearly within the same area, nonetheless because committed by a state. Other reported shipping cases are of the same character. The Charkia collision case and the Porto Alexandra salvage, a case should have been decided the other way. In order to appreciate the force of what Lord Wilberforce is saying, let me remind you, if I may, of Porto Alexandre, which can be found at page 1591.
Sorry, page again.
1591.
Thank you.
And it runs through to page 1600. Now, the Porto Alexandre was a Portuguese state-owned trading vessel. She came into the Mersey and got stuck in the mud. She was salved by 3 Liverpool tugs, apparently without a salvage contract. When Portugal refused to pay salvage, the salvors commenced proceedings against the vessel. The Court of Appeal eventually held that the English courts could not hear such a claim based on what was subsequently described as a misunderstanding of the Parliament Belge. But the conclusion is not what concerns us. It is that Lord Wilberforce expressly states that the matter should have been decided the other way, that is, that Portugal should not have been held to be immune, notwithstanding the fact that the salvor's claim did not depend on any positive act, commercial or otherwise, done by the vessel. He does not say, for example, that as Portugal's ownership of the vessel was the only fact giving rise to the claim, that Portugal was immune from the claim in salvage. Now, why is this the case? Well, it's for 2 reasons. First, because the maritime circumstances is an essential ingredient of the cause of action. And second, because the restrictive immunity does what its name suggests. A state is not immune in respect of claims deriving from acts done by the state within the trading or commercial sphere. If it were otherwise, a state could in every case claim immunity from a common law salvage claim, an outcome which would be inconsistent with the restrictive theory. The relevant activity that gives rise to the claim in salvage is that the owner of the goods has exposed itself to the risk of salvage through its involvement in the maritime circumstances.
Presumably the critical point in the Porto Alexandra is that the vessel was being used, although owned by the state, was effectively being used as a merchant ship.
Correct.
So if it hadn't been, then Lord Wilberforce would say it was rightly decided. But it was still on the high seas, still could sink, could still be salvaged. So what's the distinction? The distinction is that in one case it was being used commercially, and in the other case it wouldn't be.
It was on the high seas for commercial purposes.
Exactly, that's the critical point. There was our cargo on the high seas for commercial purposes. That's the issue, isn't it?
It is the issue, and our case, as you've heard, is short and simple, that if one enters into commercial transactions, or if the context is a series of commercial transactions which have resulted in the cargo being on the high seas and exposed to the danger, you as the owner have placed your cargo into that position, and that is
you say this, that in our case, just as in the Porto Alexandra, the relevant government was engaged in a commercial activity.
Correct. I mean, the correct analysis under the restrictive theory is that it is for the state to establish that its act was a sovereign act. That's getting it the right way round.
The State Immunity Act puts it the other way around.
The state immunity does, but as Lord Sumption explains in Ben Carbuche, that's a drafting technique. But the restrictive theory is quite clear that a state is not immune unless it can show that the relevant acts are wholly, and I'll come to that in a moment, are wholly sovereign activity.
Right.
So if I may then return to Lord Wilberforce, page 1228. After the passage I've just looked at, F to G, he refers to Trentex. Similarly, and the same is true of the acts in issue in other countries relating to the Nigerian cement purchases, the relevant act was simply a breach of a commercial contract and was treated as such. Nonetheless, though committed by a state or department of state for reasons of government, the purpose for which the breach was committed could not alter its clear character. So we see Lord Wilberforce here is looking at the acts inherent in the particular factual matrix. Where there is an absence of a sovereign act, he considers the matter to be essentially commercial, such that the state is not entitled to immunity, and we see that confirmed at page 1232, B to C. The conclusion which emerges is that in considering under the restrictive theory whether state immunity could be granted or not, the court must consider the whole context in which the claim against the state is made, with a view to deciding whether the relevant acts upon which the claim is based should in that context be considered as fairly within an area of activity, trading or commercial or otherwise of a private law character in which the state has chosen to engage, and whether the relevant acts should be considered as having been done outside that area and within the sphere of governmental or sovereign activity. And we can see how he applies this to the player larger lower down the page at 1232 G. Whether the Republic of Cuba can claim immunity depends, if I am right as to the law, upon an examination of those acts in respect of which the claim is asserted. The appellants are certainly able to show as a starting point that the vessel was engaged in trade with the consent, if not with the active participation of the Republic of Cuba. They were doing business with a foreign government, to use the Victory Transport formulation. The question is whether the acts which gave rise to an alleged cause of action were done in the context of the trading relationship or were done by the government of the Republic of Cuba acting wholly outside the trading relationship and in the exercise of the power of the state. And going on to the top of the next page at A, in my opinion, it must be answered on a broad view of the facts as a whole and not upon narrow issues as to Cuba's possible contractual liability. And then lower down the page at E to F, he continues, does this call for characterization of the act of the Republic of Cuba in withdrawing Playa Larga and denying the cargo to its purchasers as done Jure Imperi? In my opinion, it does not. Everything done by the Republic of Cuba in relation to Playa Larga could have been done, and so far as evidence goes, was done as owners of the ship. It had not exercised and had no need to exercise sovereign powers. It acted as any owner of the ship would act through Mambisa, the managing operators. It invoked no governmental authority. And then his conclusion at the top of page 1234, A to B, first complete sentence, it is precisely to protect private traders against politically inspired breaches or wrongs that the restrictive theory allows states to be brought before a municipal court. It may be too stark to say of a state, once a trader, always a trader, but in order to withdraw its action from the sphere of acts done iure gestionis, a state must be able to point to some act clearly done iure imperii. Now, we say 5 relevant propositions of law may be derived from this authority. First, application of the restrictive immunity depends upon 1232G and other places, an examination of those acts in respect of which the claim is asserted, referred to as the relevant acts. The central question, 1232G, is whether the relevant acts were done in the context of the trading relationship or were done wholly outside the trading relationship and in the exercise of the power of that state. Second principle, each of the acts to which immunity does not attach is an act, quote, an act of a private law character such that a private citizen might have entered into it. Sovereign acts to which immunity does attach takes place wholly outside such private activity and, quote, in the exercise of the power of the state. The duality is therefore not so much between sovereign and commercial acts as between sovereign and non-sovereign acts. Third, when determining whether the relevant acts are sovereign or non-sovereign, it's not enough to look at the acts themselves. The question, page 1233A, must be answered upon a broad view of the facts as a whole and not upon narrow issues such as the state's possible contractual liability. In other words, the court must consider the whole context in which the claim against the state is made. Fourth proposition, once a state has committed itself to commercial acts such that it cannot claim immunity from claims arising therefrom, then in order to change that position, it must revert to acting solely, wholly as a sovereign. Thus, quoting from page 1234B, it may be too stark to say of a state once a trader, always a trader, but in order to withdraw its action from the sphere of acts done iure gestionis, a state must be able to point to some act clearly done iure imperii. Fifth, when undertaking an assessment of this kind, what matters is the character of the acts themselves. The intention behind those acts is irrelevant. To complete the picture, could we turn shortly back to Lord Sumption in Benkarbush, page 639.
These are very broad principles, but we've actually got here some specific rules that deal with the situation in the Act and the Convention. I can't see how stating these very general principles is going to assist on that.
Well, in our submission, in accordance with guidance given by the courts, the process of interpretation is to be done having regard to and guided by the restrictive theory. And therefore, those general principles are all interpretive aids, and any construction...
well, fine, but insofar as the last one, if you're suggesting that the purpose is not relevant, but it's only the Act looked at in itself, well, that's flatly contrary to Article 3.3 of the Brussels Convention, so it's not going to assist in construing that.
In our submission, 2 points. It is going to assist in construing the statute, because if there is an inconsistency between the Brussels Convention and the restrictive theory, then that's got to be grappled with, and one's got to work out, well, what was in the mind of the drafter. and as we've seen, the drafter was, and as I will show in a moment, when the statute was introduced in Parliament, it was presented on the basis as to bring the law into line with customary international law.
Well, it was also presented on the basis it would enable the UK to sign up to its obligations under the Convention and not to introduce a regime which would be inconsistent with those obligations.
But if there is an inconsistency between the restrictive theory and the Brussels Convention on a particular reading of it, then this court is required to come to a view as to what the drafter of the legislation intended.
I'm not convinced at the moment that these very broad principles, articulated in a quite different context, are going to help us with the specific application of them to the particular question that we're asked to deal with. It wasn't contemplated by the House of Lords. And as to which it's quite unclear how it could be said that there is a customary international law which is inconsistent with what the Brussels Convention the parties to the Brussels Convention had agreed. Well, you say it's taken into account in construing it, but
the Brussels Convention was merely the one of the sources to which the drafter looked in producing the State Immunity Act. But the State Immunity Act contains lots and lots of material other than...
It's only Section 10 we're primarily concerned with here.
Yes.
And that's to give effect to the Brussels Convention.
Yes.
I mean, it wasn't intended to change the Brussels Convention, was it?
It was intended to reflect what the draft, how the drafter...
The intention, Parliament may have got it wrong, but Parliament was giving effect domestically to the Brussels Convention. Your submission is they got it wrong. If your arguments on construction of Section 10 fail.
Well, if my interpretation of the Brussels Convention is correct,
yes,
then we say then all is well.
Yes.
Even if
you're
it's
wrong about
if it's
that.
wrong, then
And the Brussels Convention has been overtaken, has it, by developments in customary international law?
Well, I think there are two answers to it. The first is that in looking at governmental non-commercial activities, clearly even within the Brussels Convention, doesn't concern only intended use, but also includes the current use. And therefore, the words in use or intended for use are the words that the drafter used in order to convey that concept.
Yep.
I was going to go back to Benkarbouche, page 639.
Bundle page.
6.3.
Page 639. Just to complete the picture, to distill what I say is a sixth principle. On page 639, paragraph 37, having shown by reference to the cases the way in which customary international law considers the restrictive theory, he comes at E to consider whether the starting point in conceptual terms is one of an absolute immunity subject to exceptions or restrictive immunity properly so called, and he sides emphatically with the latter. The fundamental difference between the parties to this appeal concerns the starting point, on the footing that customary international law must require the United Kingdom to treat Libya and Sudan as immune. The Secretary of State submits that it does. This is because in his submission, state immunity is absolute unless the case is brought within an internationally recognised exception to it. This submission, if it is correct, would considerably broaden the scope of state immunity in customary international law by extending it to any group of claimants about whom there was a diversity of state practice. But in my view, it is not correct. The rule of customary international law is that a state is entitled to immunity only in respect of acts done in the exercise of sovereign authority. And then moving forward to page 648, in a passage at D to E, he states that the third point that can be derived from history is that the adoption of the restrictive doctrine has not proceeded by accumulating exceptions to the absolute doctrine. What has happened is that governments, courts and writers of authority have been prompted by the widening scope of state operations and their extension into commerce and industry to re-examine the true basis of a doctrine originally formulated at a time when states by and large confined their operations in other countries to the classic exercises of sovereign authority. The true basis of the doctrine was and is the equality of sovereigns, and that never did warrant immunity extended beyond what sovereigns did in their capacity as such. And then he quotes a passage which we've already looked at from Il Congresso. So from this authority, a sixth relevant principle can be derived. When applying restrictive immunity, there is no assumption that the state is immune. Immunity will only attach to wholly sovereign acts. These six principles taken together establish what restrictive immunity requires and provide its principled underpinning, at least as far as English courts are concerned. We have those set out in our written case. In the light of these authorities, there can be little doubt that the courts applying common law would have concluded that the RSA is not immune from the court's adjudicative jurisdiction. What is missing from the factual matrix in the instant case is any act done by the RSA solely as a sovereign act. From the time the silver was purchased to the present day, the RSA has done nothing that could not be done by a private person. No immunity attaches, and that is the end of the story. So that is the scope of the restrictive theory in customary international law. It is said against me that the test for the restrictive theory, as I have explained it, pertains to in personam claims only, and that in rem claims are different because there's no direct active state involved. To which I will say Lord Wilberforce had no difficulty in applying his description of the restrictive theory to the Porto Alexandre, a classic in rem case, so he did not conceive of any difference between the two classes of claim. And what about the intended use of the property under the restrictive theory? In Argentum's submission, this is of limited relevance at common law. If it's right that Lord Wilberforce's description of the restrictive theory is of equal application to in rem and in personam claims, on the basis that the state's use of property is the relevant act, then it follows that his comment on the relevance of a state's intent also applies. It is usually irrelevant unless it can somehow shed light on the character of the acts, the use in question. The Republic put forward several cases that it says assist it in this respect. I hope to take my response quickly to those. Bar one, they do not support the idea that the state's intended use of its property can determine its immunity. First case is the Schooner and McFadden case, page 1949. I'm not going to invite you to go to these cases, just make comments on it. This
Schooner Exchange, page
1949.
Thank you.
This was a case in which the state converted a trading vessel into an armed schooner, at which point it was arrested. The current status, its actual use, is what determined the vessel's immunity, not its intended use. Then the chart here, page 668. This was the case in which Sir Robert Phillimore held that a state-owned trading vessel was not immune from a claim in rem. Again, this was a case in which the state's actual use of the vessel was determinative of its immunity. In the Parliament Belge, page 1273, this was a case involving a mail packet that was subject to arrest. Although the Court of Appeal seemed to indicate that the vessel was destined for use as a basis for its immunity, its application of the test turned entirely on the present use of the vessel. In this case, destined seems to be something of a figure of speech. And then finally, the Christina, page 717. This was a case in which a claimant attempted to arrest a vessel that was subject to a decree of requisition by the state. Again, although some of the members of the House of Lords do refer to the ship as being intended for state use, the actual basis of the immunity, the decree of requisition, was already in place and operating. And although the decision is admittedly unclear, it can equally be read as a case where the state's actual use of the vessel and not its intended use was key. Moreover, each of these cases is a case decided under the regime of absolute immunity. In my submission, they should be treated with caution for that reason alone. Only one decision relied upon by the RSA is actually a case of restrictive immunity, and that's the Philippine Admiral, page 1279. If we could turn up, please. I said 1279, I meant 1297, I apologise, and I was going to invite you to turn to page 1327.
Sorry,
1297.
97, thank you.
It's at, where I'm going to take the court is 1327, 1327. This was a case involving seizure of a trading vessel operated by a private party but owned by the Philippines. It ended up before the Privy Council sitting as the Court of Final Appeal for Hong Kong. And at 1237, this is the judgment of their lordships delivered by Lord Cross of Chelsea.
Sorry, which page you on?
1327.
Thank you.
At C, we can see the crux of the analysis. The question arises whether the Philippine Admiral can properly be regarded as a mere trading vessel, or was at the relevant time, for one reason or another, a ship publicius usibus destinata. In order to answer that question, one must consider the past history of the vessel in question, since she becomes the property of the foreign state, and also the use to which she is likely to be put by that state in the future. We see immediately here that what the board is saying is that while intended use may be relevant, it forms part of a more holistic examination of the state's property. And then immediately below, we see a lengthy analysis of the ship's past use as a commercial vessel, and then this is used as the basis for the board's conclusions on immunity. Picking up at C to D, throughout her life, the Philippine admiral has been operated as an ordinary merchant ship earning freight by carrying cargoes, and their lordships agree with the judges in both courts below that the fact that the liberation was subject with regard to her to the provisions of the reparations law and the contract with the Commission does not mean that she was not to be treated as an ordinary trading ship for the purposes of the doctrine of sovereign immunity when these proceedings started and when the claim was made. So again, what this case seems to be is yet another example of a situation in which the state's actual use of the vessel is determinative of immunity. And the board...
Well, looking at section 10.4, I would agree with your submission that it must be the present use of the ship that is almost always, if not always, decisive, and not some proposed future use.
Well,
but the opposite, arguably, is true of the cargo.
I understand.
Which none of these cases are considering.
No, but there are no cases which have considered it. But we're looking at the principles by which the courts, in the context of the restrictive theory, come to the conclusions to which they come. The board then goes on to discuss the relevance of intended use at 1327E. It is, of course, possible that a foreign sovereign might base a claim to immunity for a trading vessel on its alleged intention to use her in the future for some different and some undoubtedly public purpose. It then goes through the difficulties that would arise in that case before noting that as the intended future use of the Philippines for the ship for trade is the same as its past use, it doesn't need to resolve the question and so leaves it open at F. But once more, therefore, the case doesn't really tell us much about the relevance of the state's intended use of its property when determining the immunity of that property from an in rem claim. Now, were the Republic to be correct that the intended use of stated property could be relevant to determining at common law its immunity from a claim in rem, outside of the situation in which intended use sheds light on the character of the actual use, the result would be, in our submission, unprincipled. If a state-owned vessel on a commercial voyage sank and was subject to voluntary salvage, it would scarcely be satisfactory if the state could evade a salvor's in rem claim on the basis that the state planned to use the vessel as a troop ship, an intention of which the salvor was entirely unaware and about which the state could change its mind at any time. As I said a moment ago, in 1978, the State Immunity Act was enacted in order to bring our law, in the words of the Lord Chancellor, into line with current international practice. And in Premier Congresso, Lord Wilberforce made the same point as I've shown you. The purpose of the State Immunity Act was to bring English law in line with customary international law and its convention obligations. Having drawn the threads together on the public international law principle of restrictive immunity and its reception in the UK under English law, let me address next the question of the law of salvage, which I embarked upon but will now continue with, if I may. I explained the particular ingredients of salvage and said that to claim salvage, the salvor has to plead and prove maritime circumstances such that the maritime circumstances form part of the cause of action. And I mentioned in passing that is true of all of the cases insofar as they rarely exist anymore under Section 20, subsection 2S of the Senior Courts Act. All of them require the establishment of marine circumstances. Now, salvage is recoverable either pursuant to a contract or under maritime law independently of contract, and the principle of restrictive immunity is relevant to the area of salvage. Where salvage services have been performed by a commercial provider for the benefit of the state, and such services form part of a commercial transaction entered into between the salvor and the state, then the state cannot claim immunity in an in personam suit brought by a salvor for a salvage reward. Can I invite you to go to the supplementary bundles authority to page 15 to the decision of Mr. Justice Gross, as he then was in the case the Altair. The English Commercial Court had to consider here a claim for compensation for salvage services against a foreign state entity. The court found that the state's entry into a salvage contract on the Lloyd's Open form with the salvor amounted to commercial activity by the foreign state within the meaning of Section 3.3 of the Act. The fact that the cargo, wheat, was being carried on board the vessel to be intended for use for public distribution in Iraq, and so was not to be used for commercial purposes, was irrelevant. And the relevant section is to be found at at page 30, paragraph 81. In the light of the decision to which I have come, Section 10.4b is of academic interest only because he decided it under Section 3.3. No question related to this section arises, and I can therefore take this topic very briefly indeed. I've already set out the terms of Section 10.4 of the Act and outlined the rival contentions. I begin with the assumption most favourable to the MOT-GBI, namely that Section 10.4b only applies if both ship and cargo were in use or intended for use for commercial purposes. As I understand Mr. Hoyle's submissions, he very properly did not dispute that the vessel was in use for commercial purposes. Furthermore, he equally properly disclaimed any suggestion that the cargo was an aid cargo, and there was simply no evidence to such effect. As it seems to me, it follows that at the time of the salvage, the cargo was in use for commercial purposes. It was at the time a commercial cargo. It had been bought from Exim, and for that matter, shipped commercially. It seems hopeless to me to contend otherwise. State immunity, accordingly, does not apply. 2. As to Mr. Hoyle's submission that the cargo was intended for use as part of the PDS, even if well-founded, that cannot affect the cargo's status as a commercial cargo at the time of the salvage. So, the 2 points to note: the fact that it could be intended use was for sovereign purposes didn't affect its actual use, and in his view, it would be hopeless for a state to contend that the entry into a contract of salvage was not a commercial transaction for the purposes of 3, but in this obiter section says that even if that were not the case, then clearly for the purposes of section 10.4, the cargo would be in use for commercial purposes. And the issue which arises on this appeal is whether the Republic is immune as respects proceedings relating to salvage recoverable under the maritime law, independent of contract. And we ask rhetorically, is there any reason why the position should be different where the salvor services are not performed pursuant to a contract, but where the salvor acts voluntarily? The Republic contends that there is a distinction on the basis that in the context of voluntary salvage, the only act is mere ownership of the silver. It follows that if the only relevant act is mere ownership, and where current use is determinative, where the salvor acts voluntary, the salvor is always immune. It follows that under the State Immunity Act, the result is the same unless the intended use of the cargo is commercial. That's the contention. And it's for that reason the question for this court one question is whether we would say perversely Section 10.4a of the Act creates distinctions between salvage recoverable independently of contract and salvage recoverable under contract, turning our law back from the position which would have prevailed under the common law had the State Immunity Act not been passed. And the reason why that's particularly relevant is that Section 10.6 of the State Immunity Act provides that Section 10.4a and b are the only routes available in cases where the state concerned is a party to the Brussels Convention. So there's no ability in those circumstances to rely on Section 3.3. One can only bring one's claim under Section 10.4a or b. Is it to be the case that there is a distinction to be drawn between voluntary salvage and contractually salvage? In our submission, that would be a perverse outcome. The state would be entitled to greater protection under the State Immunity Act than the common and customary international law positions it was intended to reflect. In our submission, the Act has not created a distinction where none existed previously. Pursuant to the common law, the Republic would not have been immune. But even if the statute creates doubt, it should be given effect in a way which is consistent with customary law, and that's the matter for interpretation, having regard to the Human Rights Act. As we've seen, its centrality to the cause of action, the maritime circumstances, and its character must be taken into account to determine the state's immunity or lack thereof under the restrictive theory. The Republic voluntarily exposed itself to the possibility of a claim in salvage when it entered into and embarked upon the maritime adventure. This is a matter which both the learned judge and the Court of Appeal had well in mind. Sir Nigel Tare, page 235, paragraph 157 and paragraph 161 and 164, Lord Justice Popperwell, paragraph 81, Lord Justice Andrews, paragraph 114. And we say when this is understood, it is fatal to the Republic's claim that its case is consistent with customary international law. The relevant acts upon which the salvor's claim include not only ownership of the silver, but also the maritime circumstances in which the Republic chose to engage. The character of that was entirely commercial, and no immunity can attach to such act. From the time it was purchased to the present day, as I've said, the Republic has done nothing to the silver that could not be done by a private person. Alternatively, even if the only relevant act is ownership, even then that was also not of a sovereign character. If a broad view is taken of the facts and the context in which the claim against RSA is made, as required by Lord Wilberforce, then the maritime circumstances must again be taken into account. As already established, the adventure was entirely commercial. If, contrary to Lord Wilberforce, a narrow view is taken of the facts, such that the ownership of the silver is considered independently of the maritime circumstances, then the same result obtains. The silver is an item that any private party is capable of owning. Compare it to an item of ownership of which it is restricted to the state, nuclear missiles sold from a sunken warship. The fact that it was allegedly intended for sovereign use in 1942 is irrelevant, as this conflates the Republic's intention as to the silver with the plainly commercial character of that ownership as such. Notice the time. Can I just one sentence more, if I may? If the liability to pay salvage does not arise from the maritime circumstances but only ownership, the result would be unpalatable. A state would, absent a salvage contract, be immune from all claims for salvage as a matter of customary international law. That cannot be correct, a view, we say, shared by Lord Wilberforce when he considered the Porto Alexandre was wrongly decided. The unpalatable consequences will, of course, in our submission, also educate the true construction of Section 10.4a of the Act when we get to it. Parliament, in our submission, will not have intended absurd consequences. As a matter of customary international law, the matter ends there, we say. The Republic would not be immune to the salvage.
What exactly is the absurd consequence?
The absurd consequence is that by mere ownership would mean that any property, any cargo owned by a state would never ever expose itself to a salvage claim at common law.
What about the in personam claims?
I'm talking about the in rem claim.
Oh, right.
Would that be a convenient moment?
It would. Thank you very much, Mr. Hoffman. We'll resume it.
Thank you, Senator.
Thank you very much.